Any mention for unlisted matter? Any mention for unlisted matter?
Please, crave your lordship's indulgence, Mills. I wanted to move in PIL unlisted. It is in my individual capacity. This pertains to felling of more than 103 healthy trees in a certain stretch of Shillong from Anjali Point to Chalupara. Now, these trees have been standing there for the last 150 years or more. And without any justifiable reasons, that's what I humbly submit before your lordships. These trees
I will serve them a copy. We'll take it up tomorrow.
My lords, I was only praying the lordships kindly take it up today because the felling is still on, my lords.
As long as you give them notice and...
I will. Yes, I'll oblige, sir.
From supplementary list, item number 1.
May it please your lordships.
Yes.
This is an appeal on behalf of the Electricity Distribution Corporation.
Yes.
What has happened is the writ court has effectively, by way of a judicial order, permitted the respondent defaulter to the tune of almost 19 crore rupees to pay the statutory electricity dues in accordance with installments of their own choosing. The writ petition, lordship, had been filed seeking consideration of certain representations made by the respondent company. They wanted that they should be permitted. They wanted to pay, yes, they wanted to pay electricity dues of approximately 19 crores by way of certain installments. So they had made certain representations to the corporation, which the respondent with the corporation considered and duly rejected for good reason. Thereafter, they filed a writ petition seeking only limited relief of consideration of those representations. The matter remained pending before the writ court and certain proposals and counter proposals were made till the appellant corporation before your lordships firmly and finally rejected all the representations, taking into account the fact that
Now
yes,
the amount that is due is on account of previous bills, or is it on account of current bills?
It's on account of previous dues, lordship.
Previous dues.
So in
dues
yes,
from which year?
Lordship, between 2021 and 2022. So in March of 22, we issued them a notice calling upon them to pay 18 crores odd, 18 crores about 90 lakh rupees odd towards those outstanding dues. They made a representation to us in March of 2022, asking us to permit them to pay it in installments. While the representation remained pending, they moved a writ petition, which is writ petition 129, seeking a limited relief, which is that the appellant corporation be directed to consider these representations. We considered it and we rejected it because we found that
the impugned order?
Lordship, the impugned order is...
Date of the impugned order?
Lordship, the impugned order was passed on 24th June 2022. There were certain errors in the order for which we sought modification. Yes. And the modification stood finally allowed on 20th of October. That order, Lordship, will find at page 33. At page 34, para 2, Lordship will find my submissions are recorded. I'm aggrieved by paragraph 6, which Lordship.
Yes, Mr. Paul.
There's
There's no
one
basis
issue.
to be.
My lords, just two issues, my lords.
No
I
basis.
will just draw your lordship's attention to one page. They had, my lords,
Tell
initially
us when
said,
will you pay? Tell us when will you pay?
my lords, we have paid 5 crores already. The next 5 crores is due,
Thank
my
you.
lords.
You've been very kind and generous.
My lords.
Tell us when will you pay? Otherwise, they'll shut off
My
your
lords,
electricity
next,
tomorrow.
within the 15th of, I'm
Forget
sorry.
15th of. They've given you 3 months' time. They've given you 4 months' time to pay in 4 installments.
No, my lords, that is what I just wanted to point out to your lordships, my lords. If your
So
lordships,
just show us the letter dated
if your lordships
26th
kindly have
of
the,
April.
my lords, first I'll just take your lordships 1 second, my lords. Your lordships may kindly have letter dated 14/4/2020 at page 70.
Page?
70, my lords. That is where these 4 checks, this entire concept of 4 installments comes in, my lords. Your lordships have page 70, my lords. Second paragraph, my lords, 4 lines from the bottom, if your lordships kindly see. However, the line starts with however, my lords. However, in the interest of justice, as decided by the Board of Directors, MECL, the payment of the total outstanding amount can be considered to be paid in 4 equal installments with interest thereof. That is pursuant to which, my lords, we paid those 4 checks to them. It all emanates from here, my lords.
It's monthly installments. Monthly installments.
My lords, at page 70, my lords,
Yes,
the word
yes,
monthly
yes,
was-
page 70, sir.
my lords.
Read the next sentence.
Brothers, I said monthly installment.
Then monthly installments.
My lords.
Do it according to this.
My lords, they were not in a position to pay it. We've
Bad luck.
paid the first
Bad luck.
installment, my lords. We
Bad
paid.
luck.
My
It's
lords, I
not,
have
it's not the court's money to, for the court to be charitable
There
with.
is no statutory right that I have, my lords. I bow down. My lords, if I may just make one small prayer. Your lordships, the first installment has already been paid. The second installment, my lords, is due next month, next week.
How much is due now as on date?
As on date, it will be 14 crores, my lords.
14 crores
19
due.
was the due.
14 crores due,
My lords.
pay in 3 monthly installments, 1 in December, 1 in January.
December, my lords, we are paying the 5 crores first. What I was praying with your lordships may keep this matter pending, my lords. I will pay, as per the timeline, my lords, I have to pay on the 21st of December, which is next week, my lords. And lordships have the matter on Monday,
In April, they give you 4 months' time,
my lords.
which should have been May, June, July, August.
My lords.
You use the court to subvert that. You pay it off by 31st December or suffer the consequences, entire amount, whatever it
My lords,
is.
they are not in a position.
Bad luck, bad luck. We don't encourage
That
this.
is to my limited instructions.
We don't
They don't
encourage
have that
this.
kind of
We
amount,
cannot encourage this.
my lords.
You'll come and use the court for this purpose. Yes.
Lordship, in fact, only one other fact. The company has now defaulted in the current due also for the month of October and November. But because of the order, the corporation has its hands tied to take any precipitative
My lords,
action.
my instructions are very specific. As on today, my lords, I can say it with, my lords, conviction that there is no default on any current dues. Insofar as the
Only
Matter of record. It's a matter of record.
record. 13,
It's a
14
matter of
crores is due, my lords. 14 crores towards the earlier amount which we had to pay. Only that much, my lords.
There's-
I have
Lordship,
to
if I may-
bow down before lordships because
Yes.
I don't have any other right, my lords. We were faced with that kind of a situation, which was why we made that prayer for
What
my
will
lords.
happen? Everyone and his brother will come and say that, give us installments. How will the power company survive?
My lords, if I may, my lords, I know that is not an explanation. But my lords, what is happening is towards that 13 crores that is due, my lords, they are charging us roughly about 20 lakhs as delayed payment charges and another 20 lakhs
That's
as
they're
interest,
entitled to
my
in
lords.
accordance with law.
Towards, my lords, current bills. And we are continuing servicing that, my lords.
That's neither here nor there.
My lords.
Only one submission. Lordship
Yes.
will have the prayer eliminated.
We'll
Prayer
give
is at
them,
page.
we'll give them time to make 10 crores by this and accept another 5 crore, but if there are any dues on account of the months of October or November, then you will be entitled to disconnect without reference to this.
My lords, I bow down.
Grateful.
I bow down, my lords.
So 14, what is the exact amount?
It will be 14 crores, my lords. It's 18 crores something, so towards that 5 crores paid, so it will be a little less than 14 crores. My lords.
Very good. Approximately 14 crore.
Approximately 14 crores.
Out of that 14 crore, you will pay 10 by the end of the month and 5 by the end of January.
My lords, may kindly keep it till the 15th of January, my lords. 15 days, only difficulty being the holiday season, my lords.
We'll give you 10 crores by 7th of January and the remaining, whatever that is, by the end of the month, January.
My lords. Your lordships would keep this matter pending, my lords, so I can come. My lords.
And we'll give them leave to disconnect upon default.
If default, my lords, that I bow down.
Including on account of current.
Yes, sir.
If your October has not been paid by now, or your November has not been paid by now,
November, they have not raised the bills, my lords. October, they have raised. October bills, the due date is not over.
October bill, the due date is not over.
17th.
Lordship, both are over. I've placed those documents on record. That's
Where
the
are
last
There is a
annexure.
default, my lords, they will discuss.
Where are they?
That's the last annexure to my writ appeal. Lordship will find that at pages 103 and
103.
105. Yes.
Which is the last date?
103. What is the
Lordship finds that
Due date is
bill of
26th. Well, it's right on top. Due date is 26th of October.
Yes.
So this must have been paid.
and then again you find at 105 for November. The due date was 25th of November 2022.
Has the October bill been paid?
My instructions are they have
Those
been
are
paid, my lords. If they have not been paid, my lords, by direct disconnection. If they have not been paid, my lords, towards current bills, they cannot be anything.
Very. The appeal arises out of an order passed on a writ petition in which the primary grievance of the writ petitioner, the respondent herein, was that its request to the appellant power company for receiving outstanding payments in installments had not been favorably considered. Full stop. The paragraph, the writ petition was disposed of by an order dated June 24, 2022, by recording a form of consent, full stop. However, since the appellant herein claimed that it had not consented to the order, it applied before the writ court for modification of the earlier order, full stop. The writ court accepted the appellant's contention that it had not consented to the initial order and modified the order by permitting the writ petitioner to pay off the outstanding dues pursuant to a mutual agreement between the parties. Full stop. Paragraph. There does not appear to be any legal right that the respondent herein could have canvassed in proceedings under Article 226 of the Constitution. Full stop. There is no grievance that the appellant herein has overcharged or has otherwise caused any prejudice or made any undue demand, full stop. Typical of Indian consumers, it is submitted on behalf of the respondent that the power company has charged for delayed payment and like amounts, full stop. However, these are amounts that the power company is entitled to charge in accordance with law if payments are not made within time. Full stop. Paragraph. Prior to the initial order dated June 24, 2022, the parties had exchanged letters and, by a letter dated April 14, 2022, the power company acceded to the writ petitioner's request to pay the then outstanding amount in installments, provided the entire amount was cleared in 4 equal monthly installments, along with the current bills. Full stop. The payment of the installments, the power company indicated that the first installment would be payable on April 18, 2022. Full stop. The operative part, the operative part of the letter dated April 14, 2022 is set out. Next line, open quote, ... However, in the interest of justice and as decided by the Board of Directors, capital B, D capital, of MEECL, the payment of the total outstanding amount can be considered to be paid only in 4 figure and then bracket words, bracket close, equal installments with interest thereof. Full stop. Further, the said monthly installments shall be paid along with current bills, and the installments shall start from April 18, 2022. Full stop. Close quote. Paragraph. The appellant herein was well within its rights to reject the prayer for payment of the outstanding amount in installments, full stop. Yet, considering the huge amount due, the Board of Directors allowed some latitude to the writ petitioner, full stop. There was no basis for the court to interfere with the term set by the appellant herein in its letter of April 14, 2022. At any rate, there was no legal right of the writ petitioner that had been infringed upon the appellant herein setting the terms that it did in the said letter. Full stop. Paragraph. The order dated June 24, 2022 appears to have erroneously recorded the consent on the part of the appellant herein. Full stop. It is clear from the subsequent order of October 20, 2022 and the court's acceptance of the power company's contention in such regard at paragraph 4 thereof, that no consent had, indeed, been given by the power company to receive the payment, the outstanding payment as directed by the order dated June 24, 2022. Full stop. Paragraph. Upon the writ court accepting that the order dated October 20, that the consent on the part of the power company was erroneously recorded in the order, the court could have granted time only upon recognizing any legal right of the writ petitioner being infringed or any grave prejudice being suffered by the writ petitioner, full stop. In the absence of either condition, comma, the court cannot, comma, in its ipse dixit, comma, modify the terms of payment or the timelines for payment, comma, particularly in respect of power supply obtained by a commercial organization that in commercial organization, full stop, paragraph. In such circumstances, comma, the order dated October 20, 2022, as modifying the original order dated June 24, 2022, cannot stand, full stop. Paragraph, however, comma, as it appears that the total amount now due is around rupees 14 crore on account of the previous outstanding, comma, apart from the current bills of October 2022 and November 2022, comma, the writ petitioner respondent is afforded some time to pay off such amount so that, comma, so that the business and the manufacturing activity are not altogether shut down, full stop. It is submitted on behalf of the appellant that the current bills for October and November 2022 that were due towards the end of either month have not been paid, full stop. Such position is disputed by the respondent herein, full stop. Paragraph, accordingly, comma, the order impugned is modified by providing as follows. 1, the current dues for the months of October and November 2022, if not already paid, comma, should be paid by December 20, 2022, comma, failing which the appellant herein will be entitled to take appropriate steps in accordance with law, irrespective of the payments made in respect of the previous outstanding amounts, full stop. 2, as far as the previous outstanding previous outstanding amount of about rupees 14 crore is concerned, comma, the respondent herein will make payment of a sum of rupees 10 crore in 2 tranches of rupees 5 crore each by December 26, 2022 and January 7 and January 10, 2022, comma, respectively, full stop. The balance amount of about 4 crore or thereabouts should be paid off by January 31, 2022, full stop. Any claim that the appellant herein may have on account of interest on the previous outstanding amount may be raised after January 31, 2022, and such amount should be cleared within a period of 1 month of the receipt of the demand in such regard.
If any, please.
In such regard, comma, if any. Demand, if any, comma, in such regard. Then, last, the failure to make payments in terms of the previous clauses, the failure to make any of the payments in terms of the previous clauses will entitle the appellant herein to take immediate appropriate action in accordance with law, comma, including affecting disconnection of the power supply, comma, if so entitled. Paragraph WA number.
Slight delay of 18.
Right at the top, in view of the good ground shown, comma, the marginal delay of
18 days.
18 days in preferring the appeal is condoned and the appeal is taken on board, full stop, then the order, and right in the end, WA so-and-so and MC so-and-so are disposed of on the above basis. There will, comma, however, comma, be no orders to cause.
I'll leave that.
Obliged.
Item number 2. Item number 3.
May it please your Lordship.
Yes.
Lordship, I have the letter 17/2/2022, which has been referred in that 1/3/2022, your Lordship.
Give him a copy, sir. And where is that thing which refers to the 17th February letter?
Lordship, that will find, Lordship will find it at page
105.
105, your Lordship.
The letter is from the Secretary Education Department to the Additional Chief Secretary.
Lordship, yes.
Now, Mr. And the advertisement is at page 72. Where is the ad?
98. Page 98. 98.
98. Applications are invited. This is the entirety of it.
My lord.
Applications below. Essential qualifications. Age limit, no age bar, reservation, application, incomplete, direct or indirect. Is this advertisement issued under any rules or bylaws or anything? It does not say so.
Lordship, yes.
It does not say so.
Lordship,
So where is the restriction, sir, if, let us say you and I,
Lordship, yes.
we had applied,
Lordship,
we would be entitled to be considered subject to age limit and things like that.
certainly, Your Lordship, certainly.
So
But only,
on the basis of this advertisement, how does the letter dated 17th February arise?
if Lordship,
17th February says, you've given him a copy.
No, Your Lordship. I did only say 3 copies, Your Lordship. I'll give him, Your Lordship.
When will you give him? After the matter is over.
I'll just. Lordship, kindly turn to the next page, Your Lordship. It appears there is one letter, Your Lordship.
That's a request from a candidate. That's
Yes,
from an
sir.
applicant. Forget that.
Lordship, yes.
Now it says with reference to the subjects, I am to inform you that there are several cases received from candidates wherein they've passed their MTET from
From
Pura.
Pura Center, Lordship,
But
yes.
so implicit in that is that there is a residential qualification. But that residential qualification does not find place in the advertisement.
Correct, Your Lordship.
Then, choice is yours. You can withdraw it and do it afresh with residential qualification, or you have to consider everyone without any residential qualification.
Lordship, let me have instruction in the matter, Your Lordship.
No, you should have had. That's why we adjourned it for today.
My lord, otherwise also this residential qualification will not be in consonance with the fundamental rights, my lord.
No.
No.
That there are judgments to show that these kind of, there can be residential qualifications over here. You can't be an assistant teacher and coming from all the way 50 kilometers outside. No. You are within an area, or you give an undertaking, and sometimes these qualifications are permitted. May not be at the assistant teacher level, but at ground level, in various conferences, Manrega and things like that, there are residential qualifications. You cannot go from Shillong to, Bagmara to do a Manrega work. It's meant for the locals over there. So in certain cases, there are.
Well, that is, we have the liberty, if they do so, my lord.
If they do so, you challenge it. You challenge it. What do you want to do?
Lordship, because Lordship, in fact, Your Lordship, as on 18/1/2022, that is at page 103, Your Lordship.
Yes.
No such application from the resident outside the degree had been received, Your Lordship.
May not have been received.
Lordship, yes.
May not have been received, but that is an allegation that they wanted to, and we have to look at the legality of it. The process is illegal. Considering your advertisement, this letter is illegal.
Lordship, then if that be the case, Your Lordship, then we'll withdraw.
and fresh.
We'll issue
Do it afresh, do it
advertisement, Your
afresh in accordance with law.
Lordship, yes.
Because in certain cases, the local things are permitted.
Lordship.
The appeal arises from an order of November 4, 2022, by which the appellant's writ petition was rejected. Paragraph. The grievance of the appellant is that when the appellant attempted to apply for the post of an assistant teacher in the Dadangre subdivision of the West Galorins district, the application itself was not entertained, as the appellant was informed that the post was reserved for local residents and persons not living within the Dadangre subdivision could not apply therefore. Full stop. The impugned order found that the allegations to the effect that the petitioner had, that the appellant herein had attempted to apply or that the appellant's application was not accepted were vague and devoid of particulars, full stop. In effect, comma, the writ court disbelieved that the appellant had made any attempt to apply for the post and, comma, as such, comma, found that the appellant could not assert any right in respect of the impugned recruitment process, full stop. Paragraph. The advertisement pertaining to the recruitment was published on December 2, 2021, full stop. In all 202 vacancies at the level of assistant teacher had arisen, and applications were invited to fill up the posts for 111 assistant teachers in Garo language, 89 assistant teachers in Assamese, and 2 assistant teachers in Bengali.
Lordship, there are 3 advertisements, Your Lordship. That Lordship
But
will find
subsequently it
that-
was reduced, my lord. The number of posts were reduced, my lord. Reduced to page 103, lords will see, reduced to 159 posts
159, Your Lordship.
by subsequent
Full
amendment.
stop. By subsequent amendments, the number of posts stood reduced to 159.
159, Your Lordship.
159.
Lordship.
Full stop. However, comma, the other terms and conditions as contained in the original advertisement of original notice of December 2, 2021, comma, particularly pertaining to qualifications, comma, remained unchanged, full stop. The conditions indicated in the original advertisement covered the educational qualifications, comma, age criterion, and reservation policy, full stop. A cut-off date was indicated for the receipt of the application forms, for the receipt of the applications, full stop. However, comma, there was no condition indicated either in the original notice or in the subsequent notices that the posts would be reserved for local residents, full stop. Paragraph. The writ petitioner has relied on where is that?
105.
105, Your Lordship.
Clarification issued by the Education Department of the state following a reference made on February 7, 2022. Full stop. By such clarification of March 1, 2022, the special officer in the Education Department indicated as follows, colon, next line, open quote. In inviting a reference to the letter quoted above on the subject, comma, I am directed to inform you that the government, G capital, agreed to the proposal to allow the candidates from Tura to apply for the vacant post of assistant teacher in Dadengre subdivision, DSD capital, based on their address, comma, EPIC or any other residential proof for verification. Full stop. Next line, dot, 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 close quote. Thus, comma, it would appear that there was a consideration as to the residential status of the applicants, comma, comma, though no such condition was indicated in the original advertisement of December 2, 2021 or in the amendments thereto. Full stop. Indeed, comma, paragraph, indeed, comma, upon this appeal court noticing that the letter of reference of February 17, 2022 was not on record, comma, the matter was adjourned and the state was requested to produce a copy of such letter, full stop. A copy, the relevant letter has been carried to court, full stop, paragraph. The reference was sought by the Secretary in the Education Department and the exact words of the letter need to be seen, colon. Next line. With reference to the subject cited above, comma, I am to inform you that there are several cases received from candidates wherein they have passed their MTET from Tura Center but are residents from Dadingre subdivision and they could not apply for the vacant post at Dadingre subdivision. Full stop. Next paragraph, open quote. The Directorate of Educational Research and Training have issued a letter requesting that the candidates may apply for the vacant post based on their address, comma, with EPIC or any other residential proof for verification and not as per the center. Full stop. Dot, 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 close quote. What is evident from the letter of reference is that while receiving applications, scrutiny was maintained to ensure that not only did the applicants reside, full stop, paragraph, it was in such circumstances that the clarification of March 1, 2022 was made that irrespective of the center from which a candidate obtained the MTET qualification, comma, as long as the candidate provided adequate evidence of residence within the Dadingre subdivision, comma, the application ought to be received. Full stop. Paragraph. It is plain from a reading of the original notice of December 2, 2021 and the reference of February 17, 2022 along with the response thereto of March 1, 2022 that a condition was sought to be read into the notice of December 2, 2021 which had not been expressly or otherwise indicated in such notice. Full stop. Accordingly, comma, and without going into the issue as to whether residential status can be made a qualification for the post, comma, it is evident that candidates who were entitled to apply in terms of the notice dated December 2, 2021 had been excluded, full stop. The same is evident from the letter of reference of February 17, 2022, full stop. Upon the matter being left to the state to either cancel the process and start a new process of recruitment in accordance with law or to abide strictly by the terms of the original notice of December 2, 2021 without insisting on any residential condition, comma, the state has opted to cancel the entire process and begin the recruitment process anew in accordance with law. paragraph. Accordingly, the appeal is allowed by setting aside the order imprium dated
November 4th.
November 4, 2022, and by accepting the state submission that the recruitment process started by the notice dated December 2, 2021 will stand cancelled. Full stop. The state will have liberty to start a fresh recruitment process within reasonable time, preferably within 2 months from date. Full stop. Paragraph. There will be no orders to cause.
Oblige, Your Lord.
Deeply.
From the meanness, item number 1.
Joy,
Well,
how are we doing?
we have filed an affidavit bringing into records the documents pertaining to the settlement for construction of compost movement.
How's the everyday situation?
As far as the evidence, they have filed the Joy Municipal Board has filed an affidavit. My lord, they have said that as far as the garbage collection is concerned, they are doing only once a week, my lord. 1 day for dry, 1 day for wet.
To clarify on that, my lord, pursuant to the last hearing, my lord, we called for a meeting with all the headmen, my lord, and in the meeting it was decided that the wet waste will be collected separately and the dry waste separately. So the time schedule was also prepared.
What is the periodicity of collection of the wet waste and the dry waste?
My lord, each locality once a week, my lord. There's
Separately once a week?
Yes.
Irrespective of commercial or residential?
My lord, commercial is separate. Commercial, we had a separate meeting with the
So
the
we are
market
talking about
committees.
the residents.
They are talking about the
So
residents.
wet waste, for instance,
Yes.
unused food
Yes.
or uneaten food.
Yes, my lord.
I dump, and after a week you take it. That's quite a punishment, is it not? Just
My lord, it was decided in the meeting, we can review it, my lord. We can review it. But it was decided in the meeting.
We'll request you.
Yes,
You decided at a meeting, but we'll request you then.
We'll review, my lord.
To at least remove the wet waste
Yes.
more regularly than the dry waste, because dry waste is still all right.
Yes.
It can be preserved, it requires space. But wet waste produces stench and invites more disease.
In addition to this, my lord,
Yes.
so that the waste does not stay in the household, we have collection centers, my lord, where, my lord, the waste can be collected and we then, my lord, collect it once a week from there. But we can review all that, my lord, not a problem.
Very well. The state has filed an affidavit indicating the settlement for obtaining land to set up a permanent compost plant. Full stop. Timelines for the completion of the construction have also been roughly indicated.
Well, 395 days. 395
Full
days.
stop. The plant is expected to be constructed within 395 days of its commencement. Full stop. Within 395 days. Full stop. Paragraph. Meanwhile, the petitioner complains of the mounting waste in Jawai and its neighborhood, and the limited limited opportunities available for the disposal thereof. Full stop. According to the petitioner, wet waste is being collected only once a week, and dry waste,
Once a week.
wet waste is being collected, according to the petitioner, both wet waste and dry waste from residential buildings are being collected on only a weekly basis. Full stop. The Municipal Board of Jawai,
Yes, my lord, Joy Municipal Board.
the Jawai Municipal Board submits that This procedure has been adopted pursuant to meetings held with headmen and the local residents, and there does not appear to be much grievance in such regard, considering that it is a temporary measure and the compost plant should be ready in about a year, full stop. Paragraph, the municipal board also submits that a separate agreement is in place with commercial bodies as to the collection of waste, and the municipal board is alive to the fact that waste cannot be allowed to remain dumped at a particular place, full stop. The municipal board informs the court that collection centers have been opened where residents and others can dump the waste for it to be collected therefrom on a weekly basis, full stop. Paragraph, there is no doubt that the Jawai Municipal Board is doing the best that it can under the circumstances, full stop. However, it may be advisable to collect wet waste at 3-day intervals rather than once a week, full stop. The Jawai Municipal Board is requested to look into such aspect of the matter, particularly since wet waste includes uneaten or rotten food, and the collection of the same leads both to foul odor and the possibility of disease in residential complexes, in residential buildings, full stop. Paragraph, let the matter appear immediately after the vacation for a further status report to be filed by the municipal board.
If I may, Malot.
Yes.
Malot, there's Dalmia Cement Bharat Limited, Malot. They have
Sorry?
Dalmia Cement Bharat Limited, Malot.
Yes.
They have set up a co-processing plant in Lumshnong, Malot. What had happened is that, Malot, they are collecting all this non-hazardous waste, such as plastic, then refuse-derived fuel, sorted municipal waste, Malot. Those, if the municipal board, Jawai Municipal Board can sort out the plastic separately, segregate they can collect, Malot, the plastic waste.
The petitioner says that Dalmia Cement Bharat.
Dalmia Cement Bharat Limited, Malot.
Dalmia Cement Bharat Limited.
Malot.
Dalmia Cement Bharat Limited has set up a
co-processing plant. Co-processing.
co-processing plant
In their unit, Malot. In Thangskai village, Lumshnong. In their cement plant.
co-processing unit in the cement plant
Malot.
near Nongstoin.
No, Malot.
Near?
Lumshnong, Malot. Lumshnong.
That's a place I haven't been to.
Malot.
Full stop. It is suggested by the petitioner that if the plastic waste is segregated by the municipal board, Dalmia Cement is more than willing to collect the same and use it in their industrial process. Full stop. The petitioner submits that it will relieve the municipal board of the burden of disposing of plastic waste, full stop. Paragraph, it would be best if the petitioner, takes the initiative for a meeting to be held between the Jawai Municipal Board and representatives of Dalmia Cement, under the aegis of the representative of the state at the local level, for some kind of mechanism to be worked out by which the waste that can be used at the plant of Dalmia Cement can be segregated, and the municipal board is relieved of the burden of disposing of the same. Full stop.
But they have entered with an agreement with the Shillong Municipal Board also, Malot. Similarly,
Paragraph, since the petitioner says that Dalmia Cement has entered into an agreement with the Shillong Municipal Board in such regard, comma, the Jawai Municipal Board should explore possibilities of entering into a similar arrangement as expeditiously as possible.
Only one hindrance, my lord, is that the village is insisting on a no objection certificate from the village for, my lord, operating the co-processing plan, my lord. That's the only hindrance, my lord. So if the village also can be taken on board, my lord.
That is a different thing, not part of this. By a side wind, we would not without taking relevant things into consideration. No, sir.
My
Well, they are the association of headmen, my lord. They should be made.
No. That should not be a
Village
side wind.
management, they can be, my lord, in a better position to settle, my lord.
Yes, call on the next matter, please.
Item number 2.
Yes, sir.
Lordship, we are being led by Dr. Saraf in this case, Lordship. But Lordship, due to some personal difficulty, actually, Lordship, Dr. Saraf is indisposed, Lordship. Okay. But Lordship, our pleadings are all complete. So Lordship will take this matter.
Appellant, Petitioner seeks an accommodation on the personal ground of senior counsel, comma, let the matter appear immediately after the vacation.
It's the only matter pending, my lord, GST. Except
Aye,
the...
okay.
We haven't seen Dr. Saraf for a long time, yes.
There's some personal difficulty. Actually, Dr. Saraf's mother is not well, Lordship.
Okay. Call on the next matter, please.
Item number 3.
This is the same matter, Your Lordship, as per the last.
Item number 4.
Who's appearing, madam?
My lord, the last occasion Mr. Mansoori appeared. The paper book is yet to be prepared, my lord.
Very well. The appellant is not represented and it is submitted on behalf of the state that the paper books may not be ready yet. Paragraph, the paper books should be prepared by the time the court reopens after the vacation. Paragraph lists the matter a week after the vacation. Yes.
Item number 5.
We'll do it along with the merits of the matter after we come back. There should not be any tearing hurry in this.
Yes, sir.
There's not much merit in this. You'll also show something, and we want to dispose of the appeal along with the thing, rather than
Doing in piecemeal.
deciding on the jurisdiction and then coming back again.
Yes, ma'am.
And last 2 or 3 days, we don't want to either tax ourselves or.
Yes, sir.
But if there are smaller matters, appeals and things like that, which can take off, like the matters that we disposed of today, we'd want to dispose them off.
Yes, Lord, sir.
Your Lordship.
All right?
Your
All
Lordship.
right with you, madam?
Yes, Your Lordship.
Though the question of jurisdiction has been heard extensively, now, though the parties have been heard on the issue of jurisdiction, it is deemed proper to dispose of the matter altogether instead of addressing the jurisdiction issue and leaving the merits to be dealt with on a later date, full stop, paragraph, let the matter appear immediately after the vacation. Give it within the first 2 or 3 days. Ask him. What are you doing? You're felling trees.
Your Lordship, I just saw in the Shillong Times, I saw the mentioning also, and I spoke to the Forest Secretary also, my Lord. He said that the Shillong Dauki Road is being expanded, my Lord.
Shillong Dauki Road is being expanded.
And for that expansion, NHIDCL has taken permission from DFO under the relevant rules, my Lord. So there are felling of trees, my Lord, that is there.
But of course, felling of trees cannot be without obtaining permission.
Yes,
but whether relevant considerations were taken into account, after all, you are the protector.
Yes, Your Lordship.
You are the protector. We don't want to impede development.
I understand, Your Lordship, but immediately...
You want to do it now or you want to do it later in the day? You want to do it now or you want to do it later in the day? You can do it later in the
process of filing it, that's the only difference.
No. You take, when will you, do you want to do it at 2 o'clock?
If it is convenient to your lordship's minutes.
Lordship,
it's convenient any time. We are going to be here.
If Your Lordship, the issue is that what the instruction I have got in law.
Will you complete the felling by?
You will stop it, Lordship, for a day or so.
Then come back tomorrow morning.
Tomorrow morning. I will stop it for a day. I will immediately instruct so that proper petition is.
Whatever has happened has happened.
Yes.
Ask them to keep on hold so that.
Yes. And I will call NHIDCL also and them also.
In the event of may I pray your lordship that
yes,
I have inherited S1 number 6 cantonment, but this comes under a defense state officer and a station commandant of the army. So that may be added as a party.
Army is not interested in doing that.
No.
They have requested the army and obtained the land from the army for this purpose after a lot of difficulty. So add whoever you want to add. Whoever you don't add and whoever is necessary, we'll add them.
I made a prayer in the petition to that effect.
Don't worry. We also noticed it and expected something like this.
It's unfortunate, but that's the least I can say.
But again, we also have to evolve. Development is necessary. You cannot, 74% of the state is still under forest coverage. Or at least those are the statistics which are revealed. And the way that you have no industry, you have no jobs, you have aspirations, you have educational levels which are increasing. Now, where will you find place for them? Where will you find place for the increasing population?
True, Milits.
So you've got to, it has to be
some
sustainable.
Balance has to be struck.
It has to be sustainable. For instance, we have been allotted a plot in Nongstoin. Beautiful, it pained me to go and see that because there are wonderful trees standing. And I said that, what about, how did we get permission? So they said that no, everything is, and I saw everything, it's been done in accordance with law. And before the felling, we have to go and plant trees. And so I have said that, not only plant trees, but ensure that at least for a year, those trees survive so that, you know that you're leaving something for posterity.
Then it can.
Otherwise, what we do is plant dead saplings, come back and say we've complied.
Yes.
Which is not what is what is required to be done.
Thanks to Mr. Paul Millot, those trees which were there just in front of Air Force Station, so they were being felled. Mr. Paul filed and then we inspected and then we found some.
There are some trees which are appropriate for transplantation.
Yes.
There are many other trees which cannot be
suggestion, Malutz.
We examined that aspect also.
Malutz, in that other matter which my learned friend was mentioning, it later transpired, Malutz, some clerk sitting somewhere had made a mistake in so far as, Malutz, the alignment was concerned. And a 3 feet deviation, Malutz, a 3 feet deviation saved at least 10 or 15 trees, Malutz.
Oh, that's wonderful. That's wonderful.
It's only with the intervention of this honorable court that came about.
Come with it tomorrow, and since the Advocate General graciously says that felling will be stopped, we accept.
Highly obliged.
कहाँ पर गिरा रहे हैं, कौन सा ट्री गिराते रहते हैं?
अरे सर क्या
Calling your sister-in-law or your sister, your sister.